and I'm sure people will be signing on as we continue, but in the interest of time, I think we'll go ahead and get started. So I am Whitney Duncan. Welcome everyone to our Anthropologists Action Network for Immigrant and Refugees webinar, providing expert testimony, promises, and pitfalls of engaging in immigration proceedings. So before I introduce our all-star cast of speakers, I wanted to thank my co-organizers, Lauren Heidbrink, Kristen Yaris, and Sarah Horton, and also the Society for Applied Anthropology's Migration Thematic Interest Group, I think that's what TIG stands for, and Immigration Initiative, and the American Anthropological Association for hosting and sponsoring us. Also wanted to just give a brief background on Anthropologists Action Network for Immigrants and Refugees. This is a group of concerned anthropologists, professionals, students, faculty, who came together really in the fallout right after the 2016 presidential election in a late-breaking session at the AAA meetings. We were concerned and dedicated to supporting the immigrant communities that we teach and that we work with, and really just came together as a network to figure out how we could best advocate and pool our knowledge, skills, and political platforms to lobby for effective and supportive policies, both on our college campuses and nationally. We've also done some lobbying at the Capitol. So we initially started, our first step was to start a private Facebook group that really grew exponentially in the weeks after those AAA meetings in 2016. And that one's called Protecting Undocumented Students, which I believe Kristen will give information about adding yourself to, or being asked to add yourself to, at the end of the webinar. And that's really to facilitate communication across campus and share resources. We also have a website and a Google group where we share resources and ideas and solidarity. And we have published an anthropology news, have done 2 executive sessions at AAA meetings, cultural anthropology hotspot series, among other initiatives. So we would love if everyone on the call would join our network so that we can keep growing and supporting each other as we work with immigrant communities in light of very restrictive and violent policies that they are confronting right now. So again, welcome to the webinar. And we're very much looking forward to hearing from all of our speakers. I have the unenviable task of keeping people to time, and the structure will be that each presenter is going to present for about 8 minutes, and then we'll have Q&A and hopefully a discussion at the end. So if you have questions, please just post them in the chat box, and Kristen Yaris will be facilitating the Q&A at the end of the webinar after we've heard from each of our speakers. Just a reminder, keep yourself muted. The only person that should be unmuted is the person presenting in that moment, just to make sure that everyone can hear and that background noise doesn't interfere. And I think that that is all I have in terms of nuts and bolts. So first, I would like to introduce Aideen Castillo, who is the managing or directing attorney at for immigrants' rights at the Centro Legal de la Raza in Oakland. Aideen will be followed by Lauren Heidbrink and Laila Rodriguez and Beatriz Reyes-Foster. So I will introduce them in turn, and we'll let Aideen take it away for now. Thanks so much.
Great, thank you. If we can go on to the next slide. I just want to say a quick thank you to everybody who's participating. We have had a long partnership with some of the people who are panelists here, but we appreciate the opportunity to be able to talk to people and encourage you to jump in and serve in the future as experts. So I'll begin with kind of an overview of how the law defines what an expert witness is. And the immigration statute does not provide a definition, Instead, that has been interpreted by various courts across the country, but the most commonly accepted definition of an expert witness is somebody who is qualified based on their knowledge, their skill, their experience, their training or education, and whose knowledge is so specialized that they will be able to assist an immigration judge or other adjudicator in understanding the evidence in the case or making a determination of fact that is at issue in the case. So at its most basic level, kind of the first thing an immigration judge or adjudicator will think about is like, does this person that's being presented as an expert possess knowledge that is greater than what a lay person would know on a particular subject matter? So kind of that's the first inquiry. And it really is a factual determination. And I know that there will be another presenter who will talk about how you can work with the attorney to establish your qualifications as an expert witness, but generally it begins with documentation, your CV, or a list of publications. And if the judge is satisfied with that, they may just accept you as an expert, but if they're not, or if the Department of Homeland Security, who is the opposing party in many of the cases, challenges that determination, you may be put on the stand and asked more questions about your background, your education, kind of those types of questions to make an assessment about your qualifications as an expert. Okay, next slide, thank you. So one of the things is that our office for many years has worked with a number of experts in a really successful way in being able to present cases that would otherwise be really challenging. And the immigration field generally is really a good opportunity to be able to turn to experts, because in all of these cases, the adjudicator is really making a factual determination, right? These are really fact-intensive cases. And often you have adjudicators, immigration judges, who don't have the background, right? It requires a really specialized knowledge, whether it's like a medical determination or terminology that they might not be familiar with. And of course, you know, it's not acceptable that they just take our interpretation as attorneys about what that might mean, because we also don't have those expertise, but we can turn to experts and have them walk the judge through questions that they may have about a case. And often, particularly under this administration, we really have seen a greater need to be able to turn to experts. And that really is in part because there has been a huge change in case law, and what feels like kind of like almost a weekly change in case law and interpretations of things that were pretty settled, determinations, terms that all of us had grown really accustomed to, and the president kind of has ordered a reassessment of those cases. We've also seen a lot of new judges that are being put on the bench and have harsher interpretations. And for us, it's really important to establish our record that our clients are able to meet the eligibility requirements, both so that we can be successful at the initial stage, often with the immigration judge, but even in cases where we have been successful, we have seen an increased number of those cases being appealed by the Department of Homeland Security. So it's really important for us to establish a good record at the outset so that we're able to be successful on appeal. And this is really where we turn to experts to be able to establish that record. So expert evidence is both through documentation or testimony, and it can happen in immigration court before an immigration judge for somebody who is in removal or deportation proceedings, and that is the vast majority of cases that we handle. But it can also be before an asylum officer, which is under the purview of an agency within the Department of Homeland Security called the Office of U.S. Citizenship and Immigration Services. Okay, next slide. So I want to talk about kind of in the context of asylum law, and this is really one of the areas that's really ripe for expert witness use, because it really is an area that often talks about, it really is based on other country conditions and things that judges and adjudicators may often really be unfamiliar with. So I'll talk about asylum law, but it's certainly not exclusive to asylum law. There are other similar forms of humanitarian relief, and I'll just name them quickly. And they're similar to asylum, although not identical: asylum, withholding of removal, and protection under the Convention Against Torture. And they're all based on harm that the person has suffered in their country of origin or is afraid of suffering if they're returned to their country of origin. And we kind of have really built expertise in this particular area, and we're seeing kind of a bigger need for a variety of experts in this area. So generally, a person who is seeking asylum must demonstrate that they have suffered past persecution, meaning that they were harmed in some way, in a serious way, so serious that it rises to the level of persecution. It can be sexual abuse, it can be that they received death threats, a combination of those things. It is a cumulative assessment. But for some individuals who were never harmed in their home country, they may still seek asylum if the conditions in their home country or in their personal lives have changed in such a way that now they have a well-founded fear of what is called future persecution. So that's the first requirement. And typically that's gathered through testimony of our clients, although sometimes we also turn to experts to be able to establish the severity of that harm. The harm that was suffered must be perpetrated by the government or by an entity that the government is unable or unwilling to control. And in those cases, it might be like a private actor, it might be a family member, it could be a group of people like a cartel or gang members. And I'll talk about on the next slide, once we get there, how experts can really help us establish that or meet that requirement. The third requirement for asylum eligibility is that the harm must be tied to or on account of one of the 5 protected grounds, which I've listed here, and that's race, religion, nationality, political opinion, and membership in a particular social group. And this relationship between the harm and the reason for the harm is what we call nexus, and that is one of the areas where we most often turn to experts to help us establish that connection. So race, religion, and nationality are a little bit self-explanatory, so I won't go into them, but political opinion is, of course, what you might expect, like electoral politics, but it has been defined more broadly to be kind of a point of view that you have that isn't shared by the rest of the community. And then membership in a particular social group really is dependent kind of on the facts of the country conditions, whether a person is viewed in a specific way in their home country, and often we turn to country conditions experts who have done extensive research in that country to be able to prove that, what we're saying, that perception is in fact true in that country. So next slide, please. So I'm going to talk about kind of the ways in which experts can help us establish those kind of requirements. So Nexus, as I mentioned, is really important because often the persecutor won't tell the person the reason for why they're persecuting them, right? And it can help us when an expert is able to say, we've seen these similar fact patterns, and to us, it's very reasonable that the reason why this person is being persecuted is, for example, because they might have a different status or a lower status in that country. It might be because of a mental health condition and the way mental health conditions are perceived or treated in that country. So we do turn to those experts for kind of their specialized knowledge, and often an attorney will turn to you because they will have done research on you and have identified what issue they would like you to speak on. It's also necessary to establish particular social group. It is kind of the trickiest category in which a person can qualify because the case law is always changing in there, but that requires kind of a definition of kind of who qualifies or meets the definition of a social group, and often you have to define the group based on the country in which you're fleeing from. So for example, you have to say, a nuclear family is defined as XYZ family members in that particular country. And it may be different from the way it's defined in the United States. And so you rely on the expert to be able to explain why that definition is accepted in that particular country. As far as whether the government is unable or unwilling to control or protect a person, that usually comes into play where the persecutor is somebody who's not a government actor. And often we will turn to experts to be able to explain why the government would not be able to assist that person. In many cases, we also turn to kind of the Department of State. They issue publications in which they talk about changes in the law in those countries, but we use country conditions experts to be able to explain in many cases where there are countries who are making legal changes to protect people, why in fact those changes are not sufficient, right? Perhaps in the implementation, they're really failing. And we turn to experts in that area to be able to explain why our clients are still likely to be persecuted if they were to be returned. And then this last piece is changed country conditions. As I mentioned, if conditions have changed in a particular country, it's important to be able to explain to the judge how significantly they have changed and why our client would be harmed under those changed circumstances. So it's kind of very country specific. So I'll turn to the last slide. And a couple of things just to keep in mind. I really want to encourage everybody not to frighten anybody from doing this, but just some things to keep in mind is there are time constraints to testifying in immigration court. Typically, the most time will be allotted is 3 hours to present an entire case. And some judges are cutting that to an hour and a half. So an expert really only has a fraction of that time to testify. You will be subject to direct examination, which is when the attorney who has requested that you serve as an expert witness will ask you questions in a friendly manner and allow you to really explain issues at length, to really demonstrate certain points that are key to the case. Cross-examination really happens when you're questioned by the opposing party, typically by the Department of Homeland Security. Usually it's unfriendly. Most often we see that in these cases, they will either directly attack the basis of the expertise, so they will allege that the person is not in fact an expert based on their methodology, their credentials, or often they might say, well, you're an expert in a very niche issue, but your attorney is using you to talk about countrywide conditions, and you really only have a specialization in one particular area. So really being able to talk about why that isn't true is really important, and you should always feel free to respond to that in a way and kind of defend your point of view. There might also be perceived to be like some sort of bias or impartiality if you have, for example, only testified for one side, like the defense or the prosecution in criminal cases. And if you've testified for both sides, it's really important to be able to talk about that. So I don't know if I'm up with time. I kind of wanted to make sure that we got through that, but I'm happy to elaborate if there are other questions.
Great. Thank you so much, Aideen. I think we are at time, and I'm sure people will have questions for you in the Q&A. Thanks so much for that wonderful overview. And now, Lauren Heidbrink, professor at CSU Long Beach. Thank you, Lauren.
Great, thank you. So I thought I'd take just a few moments and talk a little bit about just kind of the nuts and bolts of where you begin as an expert witness. So I began this work about 20 years ago when I worked at a torture treatment center in Chicago, and I was recruiting and orienting volunteer psychologists and physicians who were conducting forensic evaluations. You know, fast forward to now, I'm providing expert witness affidavits and testimony, not only in immigration court, but also as a guardian ad litem for children in family courts. But I'm going to focus on the immigration context primarily. And I have to say up front, you know, while I've been involved in this work for over 20 years, I've always been very ambivalent about participating in such a violent system, which reduces the complexity of people's lives into a few narrow legal categories, and which really compels survivors to testify in adversarial proceedings. And so I think that kind of informs my work, where I try to avoid the simplified tropes and kind of broad strokes that many judges are relying upon to make, or attorneys even, to make successful claims. So in this really difficult context, really trying to focus on the knowledge that I can bring and inform the proceedings. I would have to say, in terms of getting involved, how you become an expert witness, you know, some of my most productive relationships have been with local legal organizations where I have some sort of ongoing professional relationship. A lot of legal organizations are overtaxed and underfunded, so self-identifying as an expert can be really helpful. There are a number of national databases that we've included at the end of this presentation I think the Center for Gender and Refugee Studies has the most up-to-date database where you can go in and register as an expert witness. Kids in Need of Defense also has a database. Because I work with children, I'm certainly working with them, and the American Immigration Council. I'd also say, one of the key referral points is word of mouth. Other scholars who are doing this work, who are doing too many and need somebody else to step up, and vice versa. There's also regional networks, if you may be involved in. I work in Guatemala, so there's the Guatemalan Scholars Network, and we often have attorneys coming on those networks to ask for experts. So what do I evaluate if I'm going to provide an affidavit? I think it's important to note here that some will be seasoned practitioners like Eileen, and others will be first-time attorneys who have taken the case pro bono through their firm that are much less familiar with immigration law. So my approach is a little bit different with those two. But typically I have an initial conversation with the attorney. They give me a brief summary of facts. I ask what the basis of the claim is, as Eileen discussed, and really try to evaluate, does my knowledge and research uniquely position me with that specialized knowledge to speak to the basis of the claim, because I know that I will be examined on that. It's an opportunity to ask questions, to learn more about the applicant, but it's also an opportunity to educate the attorney on the national and local context that might shape the claim. Give you a very simple example. I had a pro bono attorney who had never done an immigration case before, was working with a Guatemalan client, and didn't realize that the Guatemalan client was indigenous and Spanish was their second language. And so asking the question, what's their indigenous identity, what's their first language, hopefully are things that attorneys would pick up anyway, but I think are things to weigh in and certainly shape the claim and their communication. I think some of the things that, there's a number of ethical issues in terms of deciding if I would decline a case. One is that if I don't work in the region, I tend not to provide an affidavit. Again, not having that specialized knowledge. And because there's so many requests that I'm getting, I feel like my efforts are best targeted at those where I'm working in that particular region. I think sometimes when the basis of the claim is ethically questionable, and the attorney is kind of unwilling to adjust to the evidence and the conversations that you have. So I'm happy to talk more about that in Q&A, but there are some situations where I think we really have to be aware of the cumulative effects of the types of arguments that we're putting forth and how we in many ways are participating and replicating this legal violence. So the stakes are really high for individuals, but I also think, we have to think long and hard about our participation and what we put down on the page and what we testify in court. I think some of the very practical considerations or time considerations, initial affidavits are very time consuming. They get easier over time, especially if you focus on key areas or structures or laws in your affidavits. They take anywhere from 10 to 20 hours. They still take me that long after 20 years. And it's because you're speaking to the specifics of the case. Again, also thinking about testimony. At the asylum office, you will not be called to testify. That's all through kind of administrative paperwork. But if you are before an immigration judge, you may be called to testify, and timing of that is not negotiable. So the judges will set their cases, a year, 2 years in advance. So whether you're available to testify. Some larger firms will pay to fly you to testify in person. I've mostly done telephonic interpreting unless it's a local, I'm not interpreting testimony unless it's a local testimony. I think it's important to know that pro bono attorneys that are working for big firms, even though their firm has taken the case pro bono, they are compensated for their time. And so I think we should be compensated for our time. I think the going rate is around $150 an hour. But that said, it's small nonprofit organizations that have no budget for this, or small firms where they're single or solo practitioners who are charging their clients. One of the things I talk about is in making it clear to write into contract with attorneys is that any fees associated with their interactions with me and time spent reviewing my affidavit or prepping me for testimony won't be charged to the client. Just want to go very briefly, some of you have experience doing this, but an affidavit can be anywhere from 5 to 10 pages. I've had some up to 20 pages depending on the detail. And every attorney is different, so you're working with them in partnership to lay out the affidavit. And I think Eileen covered what makes us an expert, but really the first part of the affidavit is speaking to your qualifications. A couple things to consider is how often do you travel to the region and what you do to maintain in contact with what's going on. So if you haven't been to the region in 2, 3, 4 years, that's certainly going to come up in cross-examination. How do you know what's going on? In terms of the argument, again, consulting with the lawyers about how to put this forward. Some attorneys want you to make the legal conclusion in the affidavit, others don't, because this is really the judge's job. But you'll send this draft back and forth to the attorney to review. You know, more often than not, we're moving through key topics or themes in the affidavit. What I try to do is really focus on the structural, historical, specific anthropological knowledge that I can weigh in on how it's impacting the client. So in some ways it's drawing that nexus on account of, some of it is discussing the harm and the reasons for harm, how a social group is defined in that particular local context. But it also is a process of offering credibility to the applicants, right? Because you're saying what they're saying in their affidavit is substantiated in research. I think one of the things that often catches me by surprise, even after all these years of doing affidavits, is that I need to speak to why the individual cannot be returned to another part of the country and be safe, right? So if young people are coming from the highlands of Guatemala, why can they not go to Guatemala City and be safe? It's not enough to say simply that they have no family or resources, but perhaps that they would become a target because they're perceived as alone and vulnerable to forced gang conscription, as an example. Only rarely have I been in touch directly with the client. Typically the attorney is the go-between. I really feel like the immigration process demands that people recount their traumas over and over again. And so I don't want to be part of re-traumatizing young people. Only when I'm know the person, or I'm the one that helped them find an attorney, or actually if I'm in the region and have opportunity to meet with the family, have I been in touch with the clients. In terms of the types of research, it's very similar to what you would do in a peer-reviewed article, right? You're relying on academic research, nonpartisan sources of data. Rarely do I rely on media unless it's reliable or unless it's specific kind of local newspapers that speak to issues relevant to the affidavit. I think it's really important to speak to the gaps in the data, to say, the most recent report may be from 2006, but these other other factors indicate that this is a prevailing issue, or in spite of these strides in the law, this continues to be the reality on the ground. So really talking about law in the books versus law in practice, and that's I think where our field work and our knowledge comes into play, of speaking to yes, it might look like the government is willing and able to protect an individual, but in fact on the ground, this is my experience, both personal in terms of research, but also through my observations, community dynamics, justice systems, talking about corruption being mundane or discrimination against a particular ethnic or social group. Those are where I feel like as anthropologists we have added value. And I'm cognizant of time. I'm happy to talk more in the Q&A about special considerations and working with children. I think kind of in broad strokes, young people don't always have the answers. There's oftentimes a lot of gaps. And so I think where experts can come in is to fill those gaps of knowledge of what was going on kind of across the nation or in a specific context. Sometimes families are very supportive in filling those gaps, but sometimes young people are on their own. And so I think also thinking about how, kind of just as an anthropologist and as someone who's working with immigrant and migrant families, how the legal process impacts their relationships with their families. So if you put forth a certain type of claim for the purposes of seeking legal relief, how that might impact their relationships with family down the line. So I think raising those questions is really important, particularly with young people. So I will stop there. Thank you.
Thank you, Lauren. And now we will move to Laila Rodriguez from the University of Cincinnati. Just a reminder to everyone to mute your audio except Laila. We're getting some background noise of microwaves and coughing. So please mute your audio. That should be the bottom left of your screen. And thank you so much, Laila.
All right, thank you. So I thought that today I would just walk you briefly through my trajectory serving as expert witness, and then offer some kind of bigger picture lessons, additional considerations that I've learned along the way. So before undertaking this work, if you have not done so before, I think it's important to ask yourself two questions, right? First of all, what do you want to accomplish, right? What's your goal? What is the purpose for you of doing this work? And then second, how are you going to accomplish that goal, right? What will work best? And for me, the answer to these questions has shifted a lot over time. Slide, please. So I first began serving as expert witness in 2013 when I was contacted by a public defender, a local public defender, who was representing a Mexican immigrant accused of sexual abuse. So this is a very different kind of a case from what we've been working on. And I can't think of a more difficult case in which to serve your first time doing this. But I wrote about this experience in this 2014 Practicing Anthropology article. And at that time, to be honest, my main reason for serving was just sheer curiosity, right? I was barely aware of anthropologists serving in this capacity. I wanted to learn how it worked. And I was also happy to make some extra money, which the public defender's office had. And so I detail some of the issues that I faced at that time in this article. But this includes, things like working with legal professionals who sometimes, oftentimes I think, have a very narrow and just even plain wrong idea about what anthropology is, what our expertise consists of, what we can offer. And I think especially in cases that are not asylum cases, this happens a lot. They tend to have a very outdated theory of culture that commits all the sins, right? Exoticizing and othering and essentializing, all that stuff. You're going to have internal conflict about whether to do this work or not, as Lauren mentioned, about whether and how much to charge for it. You're going to realize how little you know about the law and the legal process, and I think it's important to just admit this ignorance, to be humble. For example, for asylum cases, right, the first stage, all the first stages, judges are not actual judges, right, and they work for the executive power, and it's important to understand that before you do this work. I think, that you're going to feel the weight of your knowledge, your findings, your data, much more than when all that's at stake is one additional academic publication, right? So in this first case that I served on, I knew that my testimony could, potentially help to put an innocent man in jail or to set free a child abuser. And this is something that weighted very, very heavily in my conscience throughout the whole process. I think that you have to find some way of being objective. And I realize, that this is a concept that many anthropologists reject to begin with. But I think you really have to think about how you're positioning yourself in this work. Slide, please. So after that initial experience, I started talking to people. I began to convene groups of anthropologists who have served as expert witnesses and organized a Society for Applied Anthropology panel that turned into this Studies in Law, Politics, and Society special issue. And in it, we address, so this is all anthropologists and one lawyer who published in this. We address some considerations of serving as cultural experts, specifically in the United States, right? So again, understanding the role that expert testimony plays in the legal process. And of course, Aideen and Lauren talked about that already. Reconciling the job of expert witness with other professional roles. It's a very different hat that you're wearing when you're doing this. Thinking through how you're going to relate to defendants differently than we do to informants or research subjects, right? There's no informed consent when it comes to this work, for example. Having to work with and employ legal concepts that have little anthropological acceptance, right? So the article in this volume that talks about that is an anthropologist who was asked to prove that somebody was of the Chinese race, right? And of course, how does an anthropologist do that? Thinking through producing your testimony in different historical and political contexts. And how do you help judges to understand culture? And this last point, I believe, is one of the most important contributions that we make with our testimony, because it has implications not just for the defendant or the person who's in the legal process at that moment, but it has the potential to transform how judges view everyone that comes through their courts. And so I always sneak in a little bit of like culture theory in my reports. Slide, please. So finally, as a Latin American and a Latin Americanist, I wanted to learn about anthropologists doing this work in that region. And I've learned since then that they are actually way ahead of us in thinking through the implications of this work. And more importantly for me, they frame it in terms of improving the access of vulnerable populations to justice, right? And so this is the way that I choose to view this work now. This is my goal. And so I don't think that providing expert testimony is, the way of doing justice, but I think it can be one form of justice. So with my Latin American colleagues, we have this forthcoming book, and I just wanted to offer kind of some final thoughts from one of my chapters in it, specifically regarding my experience serving in asylum cases. So for asylum seekers especially, right, Aideen talked about this, right, that states are making it increasingly difficult to apply for and to obtain asylum. And so I believe that this anthropological expert testimony is one of the very few tools that exist to help make the process more fair, to kind of tip the balance a little bit more the other way. Despite this belief I choose to hold on to, the fact remains that the number one determinant of whether somebody secures asylum or not in the United States is what judge they happen to get. To my knowledge, there is no systematic effort in the United States to document the actual effects of expert testimony. This is all experiential. My experience talking to other anthropologists, talking to lawyers. I've begun a little bit of work on this, and I know some colleagues in Chile are doing this as well, but this is an area really that is kind of a big blank. Well, coding yourself as an expert, Lauren talked about this, so I don't want to repeat what she said, but I agree, right? Also providing strategic information on the CV, formatting your CV very differently than you would do for, applying for an academic job or something else. Although in academic scholarship, we're supposed to place higher value on peer-reviewed publications, I choose to actually support my testimony as much as possible by data and publications from US government agencies, followed by data from international nonprofits, national nonprofits, and if need be, academic literature as a last resort. And again, this is an assumption that I have. I don't know the actual effect of this. Also, as has been explained, right? So to secure asylum, you have to provide evidence, right, that you are a member of one of these social groups or other categories, and persecution based on that membership. And that's really the lawyer's job. However, in the testimony, I also attempt to frame the applicant's social identities as culturally meaningful and subject to discrimination or persecution, right? So for example, being a boy who lives on the streets does not have the same cultural meaning in my current city of Cincinnati than it does in Guatemala. And I have to explain that to the judge. Even though you work very closely with the lawyer, the judge is your audience ultimately. Also, another strategy that I do, of course, always request to see the client's statement. Lawyers usually provide that from the beginning. But ask if you can have some follow-up questions. I've started talking to local lawyers about how they could be conducting these interviews when securing these statements, right? I found in one case, for example, there was nothing mentioned about this person having an indigenous status, which was very important in the statement. And then finally, in my personal experience, the most effective testimonies end up actually, as Lauren said, essentializing people, right? And portraying a single narrative about them. And I know this is something that other anthropologists have written about. And while this is, again, unacceptable in our discipline, and I agree with Lauren's concerns about this, I have come to terms with it when I keep in mind my ultimate goal, right? This is something that I don't like, that I'm gonna do if it's gonna help this person secure asylum. So that's all I wanted to bring today, and I'm happy to discuss any of these points further if you have questions about them.
Thank you very much, Laila. That was great. And now Beatriz Reyes Foster from University of Central Florida.
Hi, everyone. It has been really rewarding listening to all of these great presentations. I'm going to be talking a little bit more about just kind of from my own personal experience. I only started doing expert testimony in 2017, and my main research has been mental health in Mexico, particularly in Yucatan. And so I did not realize that I could even provide expert testimony. I didn't know that this was actually that I actually had knowledge that could be used to help people not be deported. And a lot of the impetus was, once I became aware that this was a possibility, was just feelings of helplessness following the election, and seeing everything that has happened since. So since I started, to be perfectly honest, I've actually have lost count of how many of these cases I have done. I get more requests than I can take on, and I try to take on as many as I can. But I have provided written testimony probably on about 20, and have provided oral testimony in about 10. I think 10 probably is lowballing it. Most of these cases have been asylum and CAT cases. Recently, though, I have had lawyers reach out to me on cases for cancellation or removal. And I think Aideen can probably speak more specifically about the law, but these are cases where the person is actually a U.S. citizen, minor child of someone who is in deportation proceedings, and the cases have to do with the harm that would actually befall them if their parent were deported and they were to go with their parent. The cases that I do are very specific. They have to do with people who suffer from severe mental illness, and these are called nationally qualified representative cases. These are clients who are so severely mentally ill that they have been deemed incompetent to represent themselves. And so, as I'm sure all of you know, if you are in deportation proceedings, you do not have a right to an attorney. However, if you are deemed incompetent, thanks to a lawsuit and case law, you are entitled to a defense. And so these are cases that are actually funded. There is federal funding available for them, and expert witnesses are compensated for them. And so the entire case essentially hinges on what would happen to this person if they were to be deported to Mexico. And so, because my research was conducted inside of a psychiatric institution, a lot of what I'm asked to do is to actually write about and describe my experiences inside the facility. And I also, like Laila, will use government reports, and I also will use reports published by Disability Rights International, which has published a series of very descriptive reports on conditions of psychiatric facilities in Mexico, and as well as World Health Organization reports, and even the Mexican government's own reports. And these cases have, they can be extremely challenging to do, but they are, but I've also have been on many of them which have been successful. I think you can go to the next slide, Whitney. So one of the things that I wanted to bring up, and I can answer more questions specifically about writing the reports and kind of these particular, the specificity of these particular cases. But one of the things that hasn't been mentioned is, in terms of cross-examination, is the importance of, once you decide to take on these kinds of cases, of curating your social media presence. The very first time I testified, I had a government attorney, and this was in a case in Houston, who had actually researched me and had printed out social media posts and actually entered them into evidence as a way of trying to get me discredited, claiming that I was biased. And then after that, I have had my social media accounts really closely examined. And one of the things that always comes as a surprise is that they have time to do this, but sometimes they do. I also had an attorney who Googled my name and found an interview that I had given the Chronicle of Higher Education years ago, where I talk about some personal information regarding being on food stamps when I was in graduate school, and the attorney actually brought this up in court and asked me direct questions about it, which was completely out of bounds. And so one of the things that is really important is being able to keep your cool under cross-examination, because oftentimes it can be really, the trial attorney can be very professional and can be, and can be perfectly okay. But then every once in a while you will get somebody who is just, who's really just trying to shake you as a way of discrediting you. The other thing that I have encountered in my own experience was I have actually received communications from a Border Patrol agent outside of the court system. They somehow, they were loosely connected with a particular case that I was on. The case was granted, and unfortunately the defendant who won the case and was not deported went out and shortly after committed a horrible crime. And the Border Patrol agent blamed me specifically because he felt that it was my testimony's fault that the case had been granted, and sent me some harassing and threatening emails to my university email address. And so being aware of what your rights are, being aware of what to do if you face a similar situation, I think is really important. In my case, the funds for the kind of work that I'm doing are managed by the Vera Institute for Justice, and they got involved, and we filed an official complaint with the Civil Rights Division of the Justice Department. I never heard from him again. I don't know what became of it, but it is important to kind of keep those things in mind, especially because under the current administration, people are more and more emboldened to engage in really questionable actions. And so I do this work because it's a very tangible way of feeling that I am doing something to help people. On the other side, there's also the fact that, in some of these cases, particularly if you're dealing with people struggling with severe mental illness, we know that the system in the United States is pretty terrible, and very often when these cases are granted, it's all not wonderful for them. For very often, as was in this particular case, people kind of have to go back to their life with very limited access to sorely needed resources. And so, this is really only a very, very small part of the challenges that we're facing. But it is really important to be aware of the fact that there may be an emotional toll to doing this work, to being prepared, and to knowing whether it's something that you can stay committed to. So I've been keeping track of my time. My time is up, but I'm happy to talk more about this in the Q&A.
Thank you so much, Beatriz. And I really enjoyed hearing from all of you. This has been super helpful and productive, and I'm looking forward to the Q&A and discussion. Thanks for moderating that, Kristen.
Sure, I'm trying to start my video, so hopefully if we don't have video, then you can hear me. Can you hear me all right?
Yes.
Okay, great. Well, thank you to the 4 presenters and also to Whitney for getting us here on time. We wanted to try to wrap up around 10:15, so that gives us about 20 minutes. And I've been trying to follow the questions that people are posting in the chat box and curate those. So I think that there's a number of questions for Laila, or perhaps Lauren also wants to weigh in on this, or Beatriz also, about how, Laila, you mentioned that you use cultural theory or culture theory to impact judges' views. So how do we do this as anthropologists without reducing people to essentialized sort of stereotypes of culture. Maybe Laila, you want to start, and then Lauren, I'm not sure if you want to jump in on that one.
Yeah, so when I mentioned culture theory, I think I was first of all talking about the lawyers, since they're sort of the first point of contact in this work. And from my experience, most people in the legal system have sort of a working definition of culture, right? That culture is something that you belong to or that you have, that it's shared equally by everybody, that culture is composed of the stuff that you do. That culture makes you do something. And that culture is simple, or that culture is some secondary trait, right? And so you dress differently and you eat different food, but that there's some essential, beliefs that are universal to human beings. So I've just encountered a lot of this, kind of talk. So, I mean, it really depends on the case, sometimes talking to lawyers, or sometimes, yes, I find ways of kind of, bringing that into the report. Just explaining that culture is dynamic, right? That culture can change, that it's not static, that it's, differentially shared, that you don't belong to a culture in the sense, that it's like a physical space that you can't, that you can just exit, at your own will. So it's just a more kind of updated idea, right? Everybody has, it's like students in an intro course, everybody has heard of the word culture, but of course, we need to kind of complexify what that means. And so sometimes I found myself having to do that. That's what I meant.
This is Lauren. I think part of the challenge I face is that, I think there are these kind of homogenizing ideas, particularly working in Central America, right? So the idea that, all Guatemalan children are coming if they had the opportunity. All children are unsafe. All children's families abuse them, right? So, and I think part of it is because the judges are seeing these cases over and over and over again, right? So they start to think that this is kind of the general reality. And in many ways, they're demonizing kin and culture, right, in the process. Oh, this is part of their culture to do these things. And so I think for me, addressing it as structural, as saying, no, let's look at the laws and the policies, let's look at the protections that exist, let's look at the child welfare system that is underfunded and unable to provide support. It really helps to show that this is a structural issue rather than a quote unquote cultural one. And I think in some ways it taking this position as the professor, right, as an educator of trying to educate the court that says, no, there are people that are happy, that have, thriving and productive lives in Guatemala, and everybody wants to leave, right? But there's something specific about this individual and their experience based on their social group or political opinion or any of the kind of basis of asylum that makes them, that's the reason why they left. That's the reason why they can't return. So to give a very simple example, right? I think often I've heard in courts, just the police are corrupt, right, in Guatemala. And so corruption is just pervasive. And I think there's a lot of truth to that. But I think being able to present to them, okay, well, the police are corrupt because of these reasons, right? There's a minimum level of education that is required, but in fact, not enough people have that level of education. Police are underfunded, or they're, have 6 months where they're not receiving their paychecks. And so then they turn to, bribes or, corruption so that they can earn an income. I think that's putting a rosy picture on it, but to try to show that, look, structurally, there are these issues within the police force that lead it to be ripe for corruption. Or look, there's corruption at the national level in terms of the government, in terms of the constitutional court, in terms of the Congress, and that trickles down at multiple levels. And so I think for me, trying to take culture, because I think the courts have a very essentialized understanding of culture, and really focusing on why the government is, perpetrating these crimes or is unwilling or unable to control other people that are perpetrating these types of persecution. So I think for me, again, really thinking about the cumulative impacts of, if you have experts in front of the judge, really advocating for this one individual, cumulatively, what's the impact on how they view the region, of how they view these types of claims?
This is Laila. I just wanted to add something quick to this. I agree with everything that Lauren said. And sometimes, for example, in the case of Guatemala, right, I do try to provide some of that historical and structural context context, excuse me. In some cases, I've written about the Civil War, but then I stopped short of talking about the role, for example, of the United States in destabilizing those countries, because I don't think there's any sympathy to it, right? So there's just strategic decisions that you have to make about how much you're going to educate and why.
Absolutely.
Thank you. There was another set of questions around how people, how you all, as when you're doing expert witnessing, manage your objectivity, or how you negotiate this sense of expertness or objectivity through these processes. I'm not sure, Beatriz or Laila too, if you want to jump in on that one.
So Beatriz here, I guess that what came to mind is so one of the things that was mentioned, that I didn't mention at the outset, was the fact that the opposing side will very often try to question just the very fact of your expertise, right? So one of the things that I had to do from the very beginning, and it's happening less and less often, I think, as judges have come to know me, because my work is, I primarily do work in San Francisco and more recently in Arizona, and that's really primarily where I have made courtroom, where I've given courtroom testimony. But one of the things that I learned to do from the very outset was to kind of describe what anthropology and anthropological research is in the affidavit, in the context of other kinds of information about the particular region, right? So one of the things that happened a lot, it happens less often now, but it still will happen occasionally, is my work is in Yucatan, right? Mexico's a very big country. And so the trial attorneys will try to claim that while I may be an expert of Yucatan, I can't be an expert for the entire country of Mexico. And so first, kind of accepting the idea that, at least from this perspective, I can claim expertise to Mexico, in the sense that the mental health care system is extremely similar across the country, and that is one of the things that I explain in the affidavit, and that I'm also always ready to respond to when I'm questioned on the stand, because that is very often where they will try to go, right? And so really, it's something that I have had to spend a lot of time thinking about. Is like, okay, well, how do I justify this particular expertise? And so very often what I will do is I will juxtapose my own firsthand research with government reports and other published accounts that confirm the claims that I am making. And I have found that to be fairly effective.
Yeah, this is Laila here. I think I'm the one who mentioned the word objectivity first, but especially in that first case that I worked on, a man accused of sexual abuse. Every minute that I worked on that case, I kept thinking, is he guilty or not? Is he guilty or not? I went to meet him in jail, and I thought I was gonna know when I looked at his face whether he was guilty or not. And what really kind of brought this home for me is, after I met this man in jail, his lawyer asked me, so what do you think? And I'm like, what do you think about what? And she's like, do you think he's guilty or not? And I said, well, I have no idea. Don't you know? And she said, I have no idea. My job is just to defend him. And so I thought, okay, so what is my job, right? And I just think that's maybe what I meant by objectivity, right? That you really need to have a razor sharp focus on your goal for serving on each case. I know this is very different than an asylum case, but I shifted from, is this man guilty or not? And I'm going to help to show that, to, I am being asked to answer this very specific question, and that's what I'm going to focus on. For the asylum cases that I've worked on, again, I try not to think about, does this person deserve asylum, right? That's not the question that I'm being asked to answer. I'm being asked to answer, can I provide evidence about this one thing, right? And so that's what I mean by trying to be objective. Like, you're not the judge. You have a very specific role to play. And so you really need to learn for each case what that role is. And then at the end of the day, everything that you provide, right, that affidavit, that initial written report, it's up to the lawyer to decide whether they're gonna use it or not anyway.
This is really helpful. We have about 5 or 10 more minutes. So if people still want to chat in their questions, they can go ahead and do that. I'm going to ask some questions that were further up the chat screen. A number of people are wanting to share resources, whether that's the CV that you use as a format when you're serving as an expert witness or affidavits themselves. We do have at the bottom of the presentation a list of resources that Lauren has put together for us. Some of these websites are have some of this information that might be helpful for you. So in addition to these websites, however, I'm wondering if the speakers think of what they think about sharing or creating some kind of resource sharing for affidavits, CVs, and things very particular to these different cases. So Beatriz has shared her email there and suggested that people contact her for the specificities of cases she's been representing on. But I just wondered what others thought about sharing somehow to make the burden of doing this type of work perhaps a little less onerous, and or this might get to the point that Laila and Lauren raised earlier, but I think particularly you, Laila, that there's no evidence or accumulation of knowledge here. We're sort of doing this as one-off as individuals. So I just wondered what, as sort of brainstorming, what people think about accumulating or accruing this kind of testimony.
This is Whitney. I'm just jumping in. If Eileen's still on, I'd be really curious around the sort of legal requirements or limitations on sharing redacted affidavits. I've been unsure when people have asked me to share my affidavits, if they're not an attorney representing someone and interested in bringing me on as an expert witness, you know, are those legally protected? And I don't know if Eileen is still on and could speak to that. Well, it's something to consider. I don't know legally, and maybe other people do, what we're allowed to share and what we are not allowed to share.
Like right here, I have asked some of the lawyers that I've worked with in the past. Usually they're okay with doing it. I've published sort of pieces of affidavits in academic publications, but I am uncomfortable just kind of putting everything out there in the world.
This is Lauren. Yeah, I agree. I think that particularly if, you know, there's a couple of approaches that I know that sociologists kind of fall between doing the personal affidavits and writing a kind of standalone report on kind of the situation of, you know, gender in a particular country or the situation of children in a particular country. And I think most attorneys that I've worked with, and again, every attorney is different, has wanted something that is tailored specific to the facts of the individual. That said, I think those types of reports are really helpful that attorneys can present as part of the kind of packet of information or things that we can draw on in terms of looking at what are the laws and practices in a particular country. But I agree with Laila. I think, you know, putting individual affidavits out there, even if they're redacted ones, is challenging. That said, I'm happy to share them individually with people. I know the 3 expert guides that we have here do have kind of excerpts and samples and formats that are really helpful. But I would encourage everyone to join the Anthropologist Action Network. And I think those are, you know, you could put a question out there. I'm doing, you know, a case in southern Mexico. Does anybody have an affidavit they'd be willing to share with me? I think doing those kind of interpersonal exchanges would be really productive.
Yes, and Eileen also says she's still on the line, but her microphone isn't working. And she says it's fine from a legal perspective to share redacted information so long as identifiable information has been redacted. So, and before we finish, I think we'll do one more question or maybe 2, but we do have some ways for you to get in touch and stay in touch with the Anthropologist Action Network. So Dee just chatted in a question about different countries in which anthropologists might be working, their question about the UK or comparing to other places where perhaps anthropological knowledge isn't valued as much as other forms of knowledge like NGO reports or psychological written testimonies, they said. And I was thinking about a similar question, Laila, that I'm looking forward to reading your new book because I'm sure it's addressed there. But you mentioned that there, you know, Latin American anthropologists have been doing this kind of work for much longer in your view. And I just wondered if you could share some of the main differences between how you found your Latin American colleagues are engaging with this type of work and versus American-based anthropologists.
I can't answer that question in the last 2 minutes that we have. I mean, it's, you know, of course, when you go from a common law to civil law system, just the role of the testimony is very different. The role of the judge is extremely different. To my knowledge, it has never been used in asylum or any sort of, you know, immigration cases. It's been used for pretty much everything else. And it responds to a regional strategy by the different judicial powers to increase, like I said, access to justice of vulnerable populations, which includes a lot of different categories, but has largely been interpreted as indigenous people. And so part of the work that, you know, my colleagues in the region are doing is trying to extend that to the population. But I will say, even though the nuts and bolts look very different, the big picture issues are the same, right? Questions from the anthropologists about whether we should be engaging in this process to begin with, you know, that's othering, right, the people that have access to this tool. Questions about the effectiveness of this testimony, right? They're just beginning to document that as well. Running into legal system professionals that have these limited ideas about what culture is. So all of that stuff is actually pretty much the same.
And this is Lauren. I would just chime in, the Inter-American Court has seen a number of cases where they're drawing on anthropologists and other social scientists and their kind of expert contextual knowledge. So that's a place where I've seen it be very effective.
So I think we'll just take one more question and then wrap for the sake of time. Annie just asked a question that I thought was interesting. It says, is there risk of damaging the chances of an asylum case when you take on or provide testimony for cases that are perhaps less urgent? And I think the question raises maybe a bigger issue that maybe some of you want to weigh in on about. In doing this kind of work, Lauren, as you said earlier, it can take 20 hours per case. Even those of you who've done a lot of these affidavits, you know, what is sort of the cost benefit of that versus putting our time perhaps elsewhere in other types of organizing or other types of endeavors? And I'm not sure there's a simple answer to this. We might all just find our own positionality, but sort of like, how do we decide which cases to take on or whether to do this at all? Sort of a big picture type of reflection. I'm not sure, Beatriz, if you wanted to say anything about that as well.
The cases I do are so specific, and many of them hinge very directly on the expert witness report. That, I mean, I guess the question about urgency, I'm not exactly sure what that's referencing, but in terms of, you know, the need to engage in this kind of work, you know, Laila was talking about objectivity, and in the kinds of cases that I do, culture is kind of besides the point, because the facts in question have to do more with what happens to people who are mentally ill when they are deported to Mexico, given the structural situation down there, right? And so it's not difficult to speak about what the conditions are in psychiatric institutions in the country. And so I don't know. I guess I'm kind of winging it here, but it's been very meaningful work, and it's been very meaningful in a very different way than my scholarly work has been. And so it's been very easy to say yes to the general idea of doing it, even though there are other kinds of conflicts, particularly, well, what happens when a case is won, right? And that's where it's maybe a little bit more conflicted. But the fact of, you know, the fact of what might happen to someone who is who is in that particular situation who may be deported, of what might happen to them if they're deported and they're alone. It makes the choice actually really clear cut for me. I don't know if that answers your question.
Yeah, I wonder if anyone else wants to weigh in before we sort of wrap up. Final thoughts, Lauren or Laila?
I agree. I'm just trying to wrap my mind around why this would damage the chances of getting asylum. I mean, I take the cases that I'm being asked to work on that I feel like I can work on, right? So I don't know, there might be a really urgent case out there from a Syrian refugee, but I'm not able to help that person, right? And so this is one thing that I can do. Are there other forms of, helping or activism where I can put my time and energy? Probably, but this is one that I'm good at based on, where I am in life right now. I have a young daughter, and so this is something that I can do at night while she's sleeping. And I agree with Beatriz. This is probably the most fulfilling part of all the professional hats that I wear. I think it blends in well with, my academic work, because I can do this work, but then I can publish academically about doing this work. And so it kind of, it makes me feel good. I don't charge for it. I feel like I can charge for other work. It's kind of a no-brainer. So as long as I feel like I can, do what's being asked of me, it's hard for me to turn down people.
This is Lauren. I was talking with Deborah Rodman the other day, who also has been doing this work for over a decade, and she was saying how difficult it was to get a group of anthropologists together to do this type of expert witness testimony. I think she's putting together a workshop at the AAA's. And so I just want to thank everybody for being here, because we had 90 people registered for this webinar. There are, a number of people who will access it once it's posted on the AAA website. But I think it's growing, right? I think building coalitions, I think training others, I think engaging with attorneys, in my case, child welfare professionals, so that they understand the context from which people are coming, so we can start to shift the narrative. So it's not just what happens in the courtroom, but what's happening outside of the courtroom that's informing those decisions. So I just want to say kudos to you all for taking time out of your busy schedules to be here, because I do think these types of coalitions and opportunities are absolutely critical.
If you are here and you have served as expert witness or in any capacity, I would really appreciate it if you could just send me a very quick email. I'm putting together a database of anthropologists so that I can start doing some of that, documented some of the effects of this work. And so I would really appreciate it if you just let me know.
That was Beatriz. So we will share the video, and also perhaps some of these great people are sharing resources in the chat box that we haven't had time to review. So maybe Whitney, Lauren, and I can kind of curate some of these comments and add them to our resource list for you all. And as participants, you'll receive a copy of this recording, which will also go up at the AAA website under the webinars link. And we just want to thank, so you can tell your colleagues about it if they missed it today. We'll also send that out to the ANIR listserv. So on this last slide, you can see some ways to stay in touch with the Anthropologists Action Network for Immigrants and Refugees. Again, we hosted this webinar today largely out of interest that was shared on the listserv, precisely because people are using the listserv to do a lot of research, resource sharing as they're doing expert witnessing. So I've seen a lot of these threads over the last couple years. And at the SFAA meetings in 2019 in Portland, the TIG on immigration had a lot of interest in doing such a webinar. So we really want to thank everyone for helping make this possible. Thank you to all 4 presenters, but also to Anne, Jeff, and everybody at the AAA that helped us provide the technological platform to make this possible. We truly appreciate your support. So there's our website on this slide here. We also have a secret Facebook account. It's very top secret. I'm sure nobody can see it. But you do have to email Whitney, and there's her email there, to get added to the group. It's called Protecting Undocumented Students, and that's the group Whitney mentioned at the outset that we began in 2016. There's a lot of resource sharing that goes on there well beyond our group now. It's out to K through 12 educators and community college educators. A lot goes on there. And then there is our website, and there's how you can join our listserv. If you have any questions, Lauren has given her email. You can email her. Also, those of us who are going to be at the AAAs in Vancouver, BC, we will do some type of a near get together. We do them at most major meetings, just informal, perhaps gathering like a happy hour. I don't think we have an executive session planned for these meetings. And then some of us are also going to Albuquerque in March for the applied anthropology meetings. And so Whitney can be a point of contact if you want to get together with us there. So we're about 5 minutes over time, so I'll just wrap and thank everyone again so much for being here today and for all the work that you're doing.
Thanks, everybody.
Thank you, bye.